Good morning, everyone, and welcome to our July 2026 Kites webinar. Speaking today, we have Matt Grellier, Partner, Head of Construction, discussing construction contract risk management and dispute avoidance. Stephanie Cairns, Senior Associate within our Residential Department, discussing the Renters' Rights Act. Christian Eagle, Partner in our Litigation Department, discussing the Building Safety Act 2022. And last but by no means least, myself, Charlotte Barker, Senior Associate within the Commercial Property Department, talking about minimum energy efficiency standards, the background and update. We hope you find the talks useful, and without further ado, I shall hand over to Matt. Thanks, Matt.
Good morning. During this part of the session, I'll provide some practical tips for construction contract risk management in each of the following phases of the life cycle of a project: procurement, contract formation, and during the contract administration and construction phase. For procurement, there's different routes by which the design and construction of a project can be procured, including traditional procurement, design and build, management contracting or construction management, partnering alliancing. However, the two main procurement routes are traditional procurement and design and build, known as D&B. With traditional, the design process is separate from construction, and documentation like drawings, bills of quantities, they're supplied by the client before the contractor tenders. Responsibility for design rests with client and their consultants. Responsibility for construction and workmanship sits with the contractor. With D&B, this works on the basis that the main contractor is responsible for undertaking both the design and the construction work. So there's more of a single point of responsibility with the contractor. There's various factors that determine the appropriate procurement route, including client objectives and the appetite for risk in relation to where design responsibility should fall, speed of delivery for a project, cost, quality. There's pros and cons of different procurement routes regarding these different factors. So it's recommended to take early advice as to the appropriate procurement route and the appropriate form of construction contract. And that's going to inform which of the industry standard forms published by JCT or NEC is going to be appropriate, or whether an entirely bespoke contract is needed. If a standard form of building contract is chosen, then consider whether amendments are required. Schedules of amendments to the standard terms of these published forms of contract have become common industry practice. They're used to reflect the strength of bargaining position between the parties, and they usually allocate risk to better protect the employer and the developer client. They're also utilised to deal with project-specific risk. For example, adverse ground site conditions, or if the project involves a higher risk building at HRB, for example, to address Building Safety Act requirements. And they're often needed to cater for the requirements of third parties with an interest in the project, such as tenants, funders, future purchasers, because there might be a need to ensure that obligations under third-party agreements, agreements between the employer client and those interested third parties, like funding agreements, facility agreements, or agreements for lease are covered off. For example, the funder might have specific requirements regarding the provision of collateral warranties, or they might insist on certain levels of professional indemnity insurance being maintained by the relevant parties. If a schedule of amendments is going to be used, then it's important to exercise caution when amending the terms. And it's also important to include the schedule of amendments in the tender pack. You don't want to move the goalposts. The contractor is understandably going to want to factor in that contractual risk allocation as part of their tender return. Also important to ensure that you're getting advice from appropriately qualified professionals, which specialists are required for the project. is an appropriately qualified, has an appropriately qualified and competent principal designer for the purposes of the construction design management regulations and the building regulations been identified and appointed? Is a quantity surveyor needed, or another particular sort of technical area of expertise? Leading up to and entering into the contract, it's important to undertake a detailed legal and technical audit of the contract documents. So that includes the technical documents such as the specification, the employer's requirements, contractor's proposals, and to identify whether there's any ambiguities or inconsistencies in or between these documents and address those sorts of things pre-contract formation. Check the final set of contract documents before the documents are signed. Are the agreed latest versions of the schedule of amendments and the technical documents, employer's requirements, contractors' proposals, and so on, have they been properly incorporated into the contract? And sign the contract in its agreed form before works commence. Parties are going to proceed at significant risk if they're on site, clashing on with the works without an appropriate formal contract in place. Turning then to contract administration and dispute avoidance during the life cycle of a construction project. Don't put the contract in the drawer and forget about it. Following the contract is crucial, and it doesn't need to be adversarial. The contract's there to provide a roadmap. Both parties signed up to it. It's all how you go about it, maintaining appropriate dialogue and collaboration. I'll run through some points now that might seem like common sense, but I think they're worth keeping at the forefront of one's mind. Ensure that there's an effective handover from the procurement team to the project delivery team, and ensure that key personnel within your business understand their roles and responsibilities regarding the construction contract, and that they can understand and apply the contract provisions timelessly and correctly. There can be grave consequences for an employer under a building contract, for example, that wants to pay less than the sum that's been applied for by their contractor, and they fail to follow the payment provisions of the contract in respect of giving payment notices and pay less notices correctly. Following on from that, follow the notice, information and communication requirements of the contract strictly. If the contract says a particular notice has got to be sent with a pink ribbon on it to a particular address, then do that to avoid technical arguments around a notice being invalid. Maintain records and an organised paper trail. This is crucial in the event of a dispute. And finally, seek internal support from colleagues and legal advice where appropriate. So that's all from me. I'm going to hand over to my colleague Steph Cairns, who's going to cover key changes to the Renters' Rights Act.
Thanks, Matt. Good morning. Today I'll be discussing the Renters' Rights Act, the key changes it's made, responsibilities for landlords and the impact it's going to have on the market. So first of all, some key changes. Section 21 notices have now been abolished, and landlords must give their tenants 4 months notice to vacate. Only in permitted circumstances, however. For example, the landlord or his immediate family wants to occupy the property. The property is being sold either by the landlord or the mortgage lender. The property is student accommodation, and the landlord requires possession to let the property to other tenants during the summer holidays. Or the landlord requires the property for redevelopment, providing that the works to be done to the property cannot reasonably be done by the landlord whilst the tenant is in occupation. Fixed term assured tenancies will cease to exist, and they have now been replaced by assured periodic tenancies. These are essentially rolling contracts with no end date until either party serves notice in accordance with the Act. Next, the landlords can no longer unreasonably withhold consent to a tenant's request to keep a pet. Previously, adverts might have contained restriction on keeping pets at the property. This is no longer permitted, and landlords must consider applicants with pets equally to those without. In circumstances, for example, in an apartment, where a superior lease prevents keeping pets, it will not be seen as unreasonable for a landlord to refuse a request. However, if that superior lease allows pets to be kept following consent from the superior landlord, it is expected that the landlord must seek this consent. Rent increases are now limited to once per year and only in accordance with the mechanism set out in the Act. So previous reviews in accordance with RPI or other index links are now prohibited. Tenants must give at least 2 months' notice of any, must be given at least 2 months' notice of any rent increase, and the rent cannot be increased in the first 12 months of a tenancy. So landlord responsibilities have increased significantly following the changes. First of all, we've got the Decent Homes Standard, or DHS, which will apply to properties in the private rental sector from 2035. New energy efficiency standards will apply from 2030. Now, what does this mean for landlords? Well, firstly, by 2030, all homes in the private rented sector will need to have a minimum energy efficiency rating of C, which for some may mean significant works are required to those properties. A decent home is defined as a home that's free from the most dangerous hazards, is in a reasonable state of repair, provides core facilities and services such as a kitchen, an appropriate bathroom and toilet, somewhere that's free of damp and mould, somewhere that provides a reasonable degree of thermal comfort, which ties into the new energy efficiency standards. And in addition, homes must be equipped with child-resistant window restrictors on all windows, which present a fall risk for children. AWAB's law will apply to the rental sector, and this is the obligation on landlords to deal with mould and other serious health hazards promptly. This comes following the tragic death of 2-year-old Awab Ishak. The obligations already apply to the social sector, and the government has now committed to applying them to the private rented sector. And although this hasn't yet been confirmed, it is anticipated that this will be implemented from 2027. Failure to comply with these regulations could result in enforcement being taken by the tenants or a complaint being made to the private rented sector ombudsman, which is expected to be operational from 2028 and will be mandatory for landlords to join. We're awaiting further information on that at present. Since the 1st of May 2026, landlords must not discriminate against those who have children or those who are in receipt of benefits. There is now a responsibility to ensure that each prospective tenant, no matter what their circumstances, has equal opportunity when it comes to renting a home. So what impact do we think the changes are going to have on the market? First of all, these are huge changes, so we know there is going to be an impact. Landlords now need to give 4 months notice to vacate, and so those wishing to sell their properties must consider when they serve notice on the tenant, whether that will be prior to marketing the property, when a sale is agreed, or when contracts are exchanged. Regardless, in our experience, many transactions take less than 4 months, and so there will inevitably be an effect on transaction times. It may be that a landlord decides not to serve notice prior to sale, but chooses to sell with the tenants in situ. However, this inevitably reduces the pool of potential buyers and may even impact the value of the property. Tenants must now give 2 months' notice to vacate a property under the new regime. Unlike landlords, however, there is no minimum term that must be surpassed before notice can be served. This means that essentially there is nothing preventing a tenant from moving in on day one after a landlord has spent significant time and cost decorating and possibly even furnishing the property, and then serving 2 months' notice on day two. This, without a doubt, will be something for landlords to be wary of, particularly those who have mortgages over their rental properties, who will need to find a way to pay the mortgage when the property is vacant. Finally, reletting has been prohibited for 12 months once a notice has been served. So if a landlord serves a notice to vacate on the tenant because of a pending sale, and that sale then falls through, the landlord is not permitted to relet the property, and that includes through Airbnb or similar sites within 12 months of expiry of the notice period. It goes without saying this will have a significant impact on the landlord in terms of cost, as an empty property is not ideal, but it also takes a potential home off the market for a significant period of time. It's possible that this is an unintended consequence of the new rules, but time will tell the impact this has. Obviously, it only came in May, so still very early in the new process. Overall, as the changes are relatively new, it is possibly too early to tell how the market will be impacted, but we are certain that with these being the largest changes to the rental sector in recent times, players in the market across the board will be affected. If you're a landlord who owns rental properties, or if you're looking to get into or out of the market, then please reach out to myself or my colleagues and we'll be happy to assist. Thank you. I'll now hand you over to my colleague, Christian.
Thanks, Stephanie. Good morning. Today I want to look at one of the most important Building Safety Act decisions handed down so far. The recent decision in Crest Nicholson Regeneration and Ardmore Construction is currently one of the most significant Building Safety Act authorities because it demonstrates how widely the courts are prepared to use building liability orders, particularly where insolvency or corporate restructuring might otherwise prevent recovery. It also confirms that adjudication awards can constitute a relevant liability under the Act, and that the court may grant anticipatory building liability orders before the underlying liability has been finally determined. In Crest Nicholson, Ardmore Group, one of the UK's most experienced main contractors, had been driven into administration in part by claims for Building Safety Act contributions being made between group companies, combined with the uncertainty around how far historic liabilities may extend. The message from the court is that liability can go further, reach further back and catch more parties than many in the market expected. Uncertainty is an issue in relation to the Act, as liability is not necessarily about your own actions and what you did or you did not do on a scheme. You might be asked to pay years later, and you need to assess whether other entities in a group or connected to the group could be liable. What the Crest Nicholson case does is strengthen the available routes to recovery for claimants, as liability doesn't simply sit with an old company. Crest Nicholson is a construction dispute, and it has much wider implications for developers, landlords, commercial property owners, agents, asset managers, and those acquiring residential portfolios. And the message is simple. The Building Safety Act has significantly expanded potential liability, and the courts are demonstrating a willingness to use those powers robustly based on the outcomes of the Crest Nicholson case. Now, why was the Building Safety Act introduced? Following Grenfell, Parliament sought to ensure that those responsible for historic building safety defects could not avoid liability through insolvency or special purpose vehicles or complex corporate structures. The Act therefore introduces a number of powerful remedies, including building liability orders, which Crest Nicholson is concerned with, remediation orders, information orders, which I'll mention later, and extended limitation periods under the Defective Premises Act. The legislation is deliberately wide-reaching. It's not bad legislation, as it creates regulation for the construction industry, and it was supposed to ease future dispute resolution and clarify decision-making, as well as improving standards and, of course, safety in the long term. It's not the easiest act to navigate or interpret, but that's where we can help. If in doubt, I would always advise to take advice at an early stage. Now, the Crest Nicholson dispute concerned the Admiralty Quarter residential development in Portsmouth. Following investigations, significant fire safety defects were identified, including defects affecting external wall systems and fire stopping. Crest Nicholson successfully obtained an adjudication award of around £14.9 million. However, the day before the adjudication decision was issued, Ardmore Construction entered administration. Ordinarily, that may have left Crest Nicholson with a judgment against an insolvent company. Instead, Crest relied on the Building Safety Act, which is powerful. So what did the court decide? The Technology and Construction Court made two significant decisions. Firstly, building liability orders can extend liability to associated companies. The court held that associated companies within the Ardmore Group could potentially become jointly liable. Corporate restructuring would not automatically shield companies from liability where it is just inequitable to make an order. Secondly, an adjudication award can amount to a relevant liability. This is particularly significant. The court confirmed that an adjudicator's decision can support a building liability order. Claimants don't necessarily therefore have to wait for a full trial. Thirdly, anticipatory building liability orders are available. The court confirmed that building liability orders may be granted before the underlying liability has finally been determined. This substantially strengthens the remedies available to claimants. So, why does this matter? Well, historic projects can continue to generate liability long after completion. Corporate restructuring may not prevent claims. Purchasers carrying out due diligence should investigate historic building safety risks carefully. Although agents may not normally be the primary target of building liability orders, they will frequently become involved in advising landlords and managing remediation projects and coordinating consultants, or dealing with leaseholders and identifying responsible parties. Understanding where liability may ultimately sit is increasingly important. The case also reinforces the importance of maintaining comprehensive records. Those records can relate to construction, remediation, fire safety investigations, which obviously are a prevalent concern, and contractor appointments. Now, I did want to just talk about, or just mention, in fact, other recent Building Safety Act cases. Time's against me, so I will just summarise those cases. So firstly, you've got BW Trading Limited, which is another Ardmore construction case. That confirmed that claims under the Defective Premises Act can be determined through adjudication, making adjudication an increasingly powerful route for Building Safety Act disputes. This is the case of 381 Southwark Park Road RTM Co Limited. That's one of the first cases considering when it is just and equitable to make a building liability order, providing early guidance on the court's discretionary approach. And then you've got BW Trading Limited and Ardmore Construction Limited information orders, which I mentioned earlier. That clarified that information orders are not available simply because liability is alleged. There must already be a relevant liability, which now includes, following the Crest-Nicholson case, an adjudication award. Together, these cases demonstrate that the courts are progressively defining and often expanding the practical operation of the Building Safety Act. Now, why is Crest-Nicholson particularly significant? Among the developing case law, Crest-Nicholson currently stands out because it confirms important principles in one decision. Building liability orders have real practical effect. Group companies may face liability, and insolvency will not necessarily prevent recovery. Adjudication awards can support building liability orders, and this is important. The courts are willing to interpret the Building Safety Act flexibly. So by that, I mean that unusually they won't just adopt a black letter approach to interpreting the Building Safety Act. So for these reasons, it's considered to be the most significant building liability order decision to date. So in terms of practical takeaways, carry out due diligence on existing residential assets. Don't assume liability ends with the original contracting company, and corporate restructures may not protect associated companies. Always keep detailed records and review historic developments where fire safety issues may arise. Consider building safety risks early during acquisition and disposals, and engage legal advisors at an early stage when Building Safety Act issues arise. in terms of my closing comments, the Building Safety Act is one of the most significant changes to construction and property liability in recent decades. Its provisions are wide-ranging, and the recent decisions demonstrate that the courts are continuing to develop the interpretation of the legislation. The courts are prepared to use the Building Safety Act to ensure genuine building safety liabilities cannot easily be avoided through insolvency or corporate restructure. The key takeaway is not simply to understand the legislation, but to recognise when specialist legal advice is required. The Building Safety Act is a powerful but complex piece of legislation. Each development ownership structure and remediation issue will turn on its own facts, and early legal advice can help identify risks and allocate responsibility and avoid costly disputes. I will leave you with a cliffhanger because I checked as at last night, and permission to appeal the Crest Nicholson case has been granted, but the appeal is yet to be determined, so watch this space. I'll now hand over to my colleague, Charlotte Barker. Thank you very much.
Thanks, Christian. I'm going to be providing an update on the MEES regulations for the non-domestic private rented sector in England and Wales. I'll also give a bit of a background as well, just by way of reminder. So by way of background, the MEES regime is the standard minimum energy efficiency regime for private rented property in England and Wales. In practical terms, it uses the property's EPC rating as a trigger and compliance benchmark. EPC ratings range from A to G, with A being the most energy efficient rating and G being the least. The current position is that landlords generally may not let or continue to let a commercial property with an EPC rating of F or G, unless the property is improved to at least an EPC rating of E or a valid exemption is registered. The government published consultations in 2019 and 2021 with a view to tightening non-domestic MEES. It was originally proposed that commercial properties should achieve an EPC rating of B by 2030, with an interim requirement to achieve a C by 2027. Given the passage of time since these proposals, the government has decided, in its interim response to these consultations, that it's going to drop the requirement and extend the period for achieving a B rating. So the government's now published its long-awaited response to the consultations on increasing the minimum energy efficiency standards. It's been labelled an interim response with some important detail still yet to come, but the government have confirmed as follows. All privately rented commercial buildings over 1,000 square metres in England and Wales will need to have an EPC rating of B or above by 2031. This represents a one-year extension from the 2030 deadline originally imposed in the 2021 consultation. Owner-occupied buildings remain outside the scope of the MEES regulations. Properties below 1,000 square metres will remain subject to the current EPC E minimum standard, and this gives SMEs and landlords of smaller assets more time and flexibility to upgrade. There will be no requirement to meet the previously proposed interim milestone of EPC C by 2027. Existing flexibility mechanisms, including the 7-year payback test, under which landlords are only required to make improvements that can be recouped through energy savings within 7 years, and exemptions including the consent exemption, devaluation exemption, and new landlord exemption, will continue to apply. In practice, the payback test may limit the impact of the EPC B requirement for certain building types, where upgrade costs are disproportionate to achievable energy. The new minimum energy efficiency standard of B for larger buildings from 2031 will only take effect once secondary legislation is in force. There is no confirmed timetable for the legislation, although the government intends to introduce it at the earliest opportunity. As indicated above, the government's response is interim. The key issues in which further government response is required are as follows. Enforcement mechanisms. So should the current penalties be increased, and should the regulators have additional powers? We're yet to see. Should there be a 6-month exemption from the MEES for shell and core-let buildings? And finally, should tenants be subject to statutory duties under the MEES? Currently, MEES applies to landlords, and the parties to a lease are left to allocate costs between them in the drafting and the lease. The government is considering whether this should be underpinned by some basic responsibilities on tenants, not to undermine an EPC rating, and a duty of mutual cooperation with the landlord. Again, we shall see what happens. So what should landlords and developers do now? For commercial landlords of large premises, the 2031 deadline introduces a clear compliance target. Landlords should plan strategically, undertake a portfolio-wide stocktake to confirm current or anticipated EPC ratings, lease expiry dates, and the applicability of exemptions. Identify potential cost-effective improvement measures, taking into account the payback test and the lead-in times required for design, procurement, and installation of energy-efficient upgrades. Review relevant lease provisions. This includes access rights, ability to undertake works, and EPC requirements. And for developers, review development agreements and agreements for lease to ensure that handover specifications and conditions precedent reflect the new minimum standard. The EPCB requirement should be factored into all new acquisitions and lease negotiations going forward. It's important to take action now and ensure that properties meet the B rating from 2031, reduce compliance risk, and protect asset value. In a market where energy performance is increasingly central to investment decision-making and property valuations, early compliance can mitigate the risk of penalties and potential reputational damage in the event of non-compliance. It's also really important to monitor further updates expected from the government, including its full response to the consultations and implementing legislation and guidance. And finally, seeking advice from trusted advisors, of course, meaning us here at Kites and any other relevant professionals to the EPC regime. This brings us to the end of today's webinar. I would like to thank you on behalf of the speakers and Kites for taking the time to join today and listen to us speak. We hope you found the session both useful and informative. A member of the team will be in touch later today with copies of the slides. We appreciate it can often be a lot of information to take in and retain, so please do not hesitate to contact us if we can be of any help on any of the topics discussed today or anything else for that matter. If you did submit a question, we will be in touch directly later today. Thank you for listening and have a pleasant day. Goodbye.